Ayanna Lee-Rivears is the founder and owner of Socacize Fitness, a global network of instructors, trainers, mentors, choreographers, and performers who lead a dance fitness program that blends authentic Caribbean and African dance techniques with effective fitness moves. In the first edition of Unlocking Law and Business, Ayanna speaks with Tanya Walker about common questions business owners may often ask. To hear this informative discussion about the intersection of business and law, keep watching.
I'm excited to ask you these questions. If I were owed money as a fitness instructor, how do I go about collecting that? So I have my own classes and I have people coming, they're paying, I have my location and I'm owed money.
Well, if you're owed money, I think one thing that business owners don't realize is that all the judge is really responsible to do is to give you judgment. The judge doesn't actually actively help you collect your money. And the reason why I start off with the end instead of the beginning is because that's very important. If you're thinking about suing someone for money and that person doesn't have any assets, sometimes you'll get a judgment that's just a paper judgment. You can't actually do anything with it. So the first thing I usually say to someone who's owed money nowadays is, let's do an asset search to see what assets that person has in their name, because that may influence how much money you're going to settle for or accept, because you don't want a paper judgment and you're not able to collect because the person doesn't have title in assets. It's hard to find the bank accounts to garnish them. So that's a very, very important consideration. So going back to your question, how do you go about collecting that is, I would suggest that you send that person a letter or an email and say, you owe me this much money. Let's have a settlement discussion to discuss resolution and a payment plan. And then you make sure that it's papered. A lot of business owners, I find, don't document agreements. They do things on a handshake. It's a relationship business. And then they come to me and they say, okay, well, this person owes me X amount of dollars. Can you sue that person? And one of the first things I say is, okay, where's your contract? I don't have a contract signed. Okay, well, they owe you, you're saying they owe you money and it was due, but where's the evidence it was due? We can use text messages, WhatsApp messages, but I think it's very important to just paper things if you can. So if you're not able to get your money or an agreement to have your money paid to you in a settlement meeting, then you may have to sue. And then you go through the steps of a statement of claim, defense, depending on how much money it is. You may end up at trial, you may not, but the goal is really to try and resolve the lawsuit because it takes a while to go through the court system, and it's also quite expensive.
Sometimes you're paying more to sue than you're getting for the money.
Yes, and you don't want to end up with a deficit, right? You already have a deficit because you're owed money. You want to end up collecting. So you want to make sure that whatever steps you take, it makes sense from a financial perspective.
Exactly. So that actually brings me to my next question. So for example, how much do you sue for if that person doesn't pay you the money, the original payment, but you still have legal fees? So would you be able to sue them for more to cover your legal fees?
Well, you would sue them for the amount that is owed to you. How the court system works, if the lawsuit is over $35,000 in Ontario, which is outside of small claims court, you are entitled to get an order in addition to your money for your legal fees. The important thing to note is the order is not really for 100%. It's usually for 60 to 80% of the legal fees. So you're still out of pocket. Okay. If you sue in small claims court, you are only entitled to get, as a payment for legal fees, a percentage of what you sue for, which is usually around 10, 15%, regardless of how much legal fees you have spent money on. The only way that you can get more than that is by asking a judge to give you more than that, but you have to show that the behavior was so extreme that it's justified. So that's important to know that you don't have to sue for legal fees. It's usually a part of the process. However, if it's over $35,000, you're only entitled to receive between 60 to 80%, typically speaking, of your legal fees when you get judgment.
I did not know that. Thank you for sharing.
You're welcome.
Okay, so my next question is, when do you know if someone you hire is an employee versus an independent contractor?
It's a good question. And there's also a new category called a dependent contractor, Ayanna.
I did not know that. Okay.
So
Please
it's
share.
really, so it doesn't really matter. Like if it walks like a duck, it talks like a duck, it's a duck. You can call it a dog, but it's a duck. And that's how the court sees it, right? So you can say this person's a contractor, right? To maybe because of tax implications. But if the relationship is characterized or seen as an employee, that's what the person's going to be seen as. So a person that's really an employee is a person where you control the hours, you control the equipment that person uses. So for example, in your business, you would someone might be seen as an employee if they only work for you and no one else, or they don't, they may work for other people, but like you're 90% of who they work for. You tell them when they check in, you tell them when they check out. In terms of work, breaks, you dictate that. Vacations, they have to get permission from you. In terms of equipment, you supply the gym. But it's really if that person has that type of relationship with you, where you have the control of kind of that person's employment relationship, then they're seen as employee. Independent contractor is someone that if they're an independent contractor for you, that means that they're permitted to work as an instructor for other gyms or other facilities, and maybe they might have 10 contracts and you're just one of them. You don't control the hours. You might just say, okay, well, you teach 1 hour a week, but they're free to do whatever they want with their time. They may even have a gym or facility they teach at, and you give them permission as opposed to your facility. So that's an independent contractor. And really the difference between that is, if you terminate a relationship of an employee, you may owe that employee without a reason. You may owe that employee pay in lieu of notice. And so that's pay for not providing notice. And that, typically speaking, is 1 week per year. But the judges have come up with their own law because they don't really like that. They don't, because it's really supposed to buy the time till you find another job, of roughly 1 month per year. So if you have an employee and you terminate that employee without a reason, and that employee may not have an employment contract that speaks to the notice period, you can be responsible for paying that employee's salary for about 1 month per year that employee has worked with you.
Wow.
Because the judges have made up that law. And so if you have a contractor that's truly an independent contractor, and you terminate the contract with that contractor, unless it speaks to pay or notice, then you don't have to pay that pay in lieu of notice. But now the judges have created a middle category called a dependent contractor, where someone is kind of paid as a contractor, but they're dependent on you, Ayanna, for their livelihood. So they're treated more like an employee. So you might have a contractor, and it's characterized as an independent contract relationship, but that person only works for you 100% of the time or 90% of the time. And the judges have said, well, we see that person more as an employee, so we'll just call that person a dependent contractor because that person depends on you. I know you don't like it, but that's just how it works.
But how does that work pertaining to like everything else? Like how would that work with taxes and
Oh, I'm not too sure how it works with taxes, and the judges are not really concerned either.
Okay.
They want the person who is the employee or a contractor or dependent contractor to receive pay to help pay that person's salary or bills until they find another job, right? So I'm sure the CRA has there's different ways to treat it with it when it comes to the Canada Revenue Agency, but judges are not necessarily overly concerned with that. They just want a person to receive money to pay their bills until they find another job.
Well, that is news to me. So if I were to
Surprise!
hire right? If I were to hire someone, do I then tell them, okay, you are considered an independent contractor?
I would say you would consider them an independent contractor. You would give them the right to work with other gyms, or just not ones that compete with you, maybe, or like any type of exercise classes that compete with yours. But they would have the right to work with other fitness facilities. And as long as, so then if they only work with you 10 or 20 or 30% of the time, they might be seen more as an independent contractor as opposed to a dependent contractor where they work with you 90% of the times.
So, okay, so we also have a corporate side of the business where we have, a team that works to help maintain the brand. So we have operations manager, in quality assurance lead, a virtual assistant. How would how would we be able to differentiate who's an independent contractor versus a dependent contractor?
Well, I would think your virtual assistant would be an independent contractor because your virtual assistant is probably free to work as a virtual assistant for other
Yes. Yeah.
companies. And
Yeah.
you don't control the hours of the virtual assistant. You
Right.
probably just say, I want these things to be done. And that the virtual assistant just has to make sure it's done. So
Correct.
that would be more of a, you don't control the equipment. The virtual assistant probably works from home or virtually.
Yeah.
So I can't see how that relationship would be categorized as a dependent contractor because you're just one small part of that virtual assistant's business. The same
Okay.
thing with others that work with you. If they work with other companies, they work from home or they have their own equipment. I can't see how they would be characterized as dependent contractors or employees. I think the big factor here is how much of their work is allocated towards you. And if it's very
Okay.
substantial, like 80, 90%, then they're going to see more as an employee than an independent contractor. It doesn't matter what you call it.
Yeah. And then so the dependent contractor. So if I had someone that's working for like 30 hours a week, but they're not receiving, let's say, employee benefits, would they be considered a dependent contractor?
30 hours a week for you,
Yeah.
and they're not receiving benefits. Well, I don't know. Like, I guess the benefits, I don't know if it's mandatory for an employee to receive benefits. I think that's of the discretion of the employer.
Okay. I'm learning a lot today, Tanya.
And you're grimacing a bit, so I know you probably don't
I
like it, but
stopped
it's good to
writing.
know.
I was making notes. I'm just gonna listen to the video again. Too much to write. This is good. This is really good. Thank you for this.
You're
Okay,
welcome.
I have another question for you. What
Mhm.
are the best practices for documenting incidents that occur during our classes to protect us legally?
Oh, I think the first answer to your question is document.
Mhm.
So make sure, I would say that you would write it down. You would make sure that the instructor that was involved in that class would probably initial it because when it comes to me as a lawyer, I have heard people say, I didn't see it, I didn't receive it, I didn't
Yeah,
get it. So
yeah.
you would keep the original copy in like a file, and make sure you just document as much as you can. If you have a manual, I would think it's also important to have the instructors sign off on having read the manual, or even what we do in our firm with our manual is that's part of the onboarding process where I meet with the employee and go through chapters with the employee before and then we before asking that employee to sign off on having read it so they can say Tanya has met with me and explained the chapters to me because I can't take it for granted with like we now have to like 28, 29 chapters. I can't take it for granted just giving something to someone. They've read it all thoroughly. Um, I think I feel more at ease with that person's knowledge if I bring them through the chapters myself.
I like that. I actually wrote that down. Onboarding process. I like that. Implementing it into the onboarding process for sure. Tanya, I do have another question. This was not something, oh, I just dropped my earring. This is not something that was on the initial questions, but um I know at the very beginning when I started Socacize, I spoke to you about the difference between licensing and franchising. And I know there's a difference, but there's also a very thin line. So where does it um, become not franchise versus license? Where is that thin line?
Well, license is, and I'll explain just for the audience what the consequences are as well, because I know you know. A license is when you give somebody permission to kind of use your brand. So someone might pay you, I believe it's up to $5,000 around that mark to uh, use your brand, use your trademark to teach the classes.
Mm-hmm.
That's what a license is. You're giving someone permission.
Yes.
Now, when it be a franchise is when the fee is higher, then I believe it's $5,000, and it's a little bit more to it than just being given permission to teach the classes. So a franchise would be like a McDonald's or a Harvey's, where you pay a franchise fee, you might have to pay royalties, you have to adhere to how they make the food, which is similar, well, to a license because they would have to adhere to how you teach the class. But I think the main difference is the royalties, the size of it. In terms of a franchise, it's usually kind of a store. That's what I find. And you have to pay royalties or you have to buy food from a certain supplier. You purchase items from certain suppliers to keep everything consistent. The consequences of having a franchise is that now, if you're seen as having a franchise, you have to provide a disclosure document. Or a disclosure document provides a lot of information about the business, so someone can make an informed decision as to whether or not they want to invest. And that also has to provide any litigation you're involved in. And with a disclosure document, you have to provide that to somebody 14 days, typically speaking, if they're just a brand new franchisee, 14 days before they can provide money to you as like a down payment for the franchise and sign the franchise agreement, because it's kind of like a cooling off period, similar to if you buy a condominium, you have a few days, I think about the same amount of time to back out of a franchise, a condominium agreement to buy a unit. So um, if you make a mistake and you charge a franchise a license fee of say $30,000 and you're seen as a franchise, that could be very harmful because then you didn't provide the disclosure document or the franchise agreement or comply with the franchise laws, which here it's called the Arthur Wishart Act. And as a result, you as a franchisor are open to personal liability and can be sued as a person, even though they decided to contract with your company.
Good to know.
I don't
That
mean
is
to
good
scare
to
you.
know. I was gonna write it, but I'm not gonna write it. I'm just gonna listen to this
We'll
video
send you
again.
video. Yes,
Yeah,
yes.
yeah. A
So
lot of valuable information, Tanya.
I'm glad. I'm glad. So hopefully that helps you a little bit. And it's great that you provided those, like you asked those questions because uh, it's very like a very interesting questions, and I can see how someone who's a business owner may not realize that they're a franchisor, as opposed to just providing a license or not documenting things. Because as a business owner too, you're so busy, it's hard to document everything. But it's really difficult if you want to terminate that employee in the future and say you're terminating them with notice or for a reason, and you don't have the reasons documented
Yeah.
because the pendulum for employment law swings in favor of the employee, meaning that the employee is going to give the benefit of the doubt, and a judge will say you as an employer should have documented things properly, or else you're subject to the liability, and it's really not fair. But I guess that's why business owners really have to try and document incidents properly because there's more consequences for the employers than there are for the employees.
1000%. one thousand
Yes.
percent. So, this is really helpful for me because we've recently, you know, re rebranded, you can say, with our whole business model. So this is very helpful. I'm gonna definitely keep this information, and if I have any other questions, I know who to call, who to reach out
Okay.
to.
Well,
But I
hopefully you
know
don't need me. Yeah.
there may not be, yeah.
Hopefully you don't need to call me, but at least this gives you a little bit of insight as to what you have to kind of pay attention to.
For sure, for sure, for sure. Thank you so much. I appreciate it.
All right. Thank you, Ayanna.